thank you for coming to a press conference here at the Ministry of the Attorney General and Legal Affairs. I've called you on an important issue, and it revolves around the ruling coming in the courts of Trinidad and Tobago today by Madam Justice Wilson, she having delivered a refusal of an injunction brought by Dr. Moonilal against a sitting of the House today, effectively to deal with a motion of privileges. This is a landmark position for Trinidad and Tobago, and it is something which, as an Attorney General, one ought to speak to. Effectively, you will know that Dr. Moonilal, through his attorneys Anand Ramlogan and Gerald Ramdean, approached the courts of Trinidad and Tobago to say that there should not be a convening of a committee of privileges to consider allegations of a breach of privileges by Dr. Moonilal. The basis for those allegations revolve around essentially some very small issues. The recusal of two members of the Committee of Privileges, Mrs. Camille Robinson Regis and Mr. Fitzgerald Hinds, and the ruling of the Speaker that there was a prima facie case. The claimants alleged, that is Ramlogan, Ramdean, and Moonilal, they alleged that there was a breach of constitutional provisions essentially, and they asked the court to take a very unusual step to intervene in the business of the Parliament of Trinidad and Tobago and to stop the Parliament from hearing a matter of privileges on an allegation of a breach of constitutional rights. Why this matter is important to Trinidad and Tobago is that it is one of the rare occasions, and certainly one of the first occasions in the Commonwealth, that someone has approached the court to say the Parliament is effectively not supreme. And it is astounding that that submission could have been made, because the submission coming to the courts of Trinidad and Tobago included the fact that one should really effectively ignore our Constitution. I wish to point out to the listening public, to the members of the media, and to the viewing public, that today's decision to reject an application for an injunction essentially upholds the supremacy of our Constitution and the immunity and privileges of our Parliament. Our Parliament derives its constitutional immunity, as you're aware, from Section 55 of the Constitution. The preamble of the Constitution in Part C and Section 1 of the Constitution also provide assistance, but our Constitution is a unique Constitution. There is only one other Constitution which resembles our Constitution in this fashion, and that's the Constitution of Canada. And our Constitution expressly recognizes in Section 55(3) of our Constitution that we incorporate the privileges and immunities of the House of Commons of the United Kingdom. That's what separates our Constitution from other written constitutions, and particularly Caribbean constitutions. Effectively, what Mrs. Ramlogan, Ramdean argue on behalf of Dr. Moonilal is that Trinidad and Tobago should find itself in a very unique position to ignore its written constitution, to ignore the uniqueness of our Constitution, and to allow a Parliament to be subjected to the court almost on a minute-by-minute basis. That would respectfully make a mockery of the separation of powers argument, and it would mean that on every whim and fancy of any sitting parliamentarian, court process could be invoked. If we took the manner in which they suggested, court process could be invoked to stop Parliament's autonomy. The reason as to why this decision is so important for Trinidad and Tobago today, in the judge rejecting the absurd allegations and propositions coming from Mr. Ramlogan, Mr. Ramdean, and Dr. Moonilal, the reason why it is important is that it preserves the autonomy of Parliament as our Constitution has set it out. I'd just like to tell you that the European courts, the courts in New Zealand, in Australia, and certainly the courts in Canada, and in particular dicta coming from the Privy Council out of a Bahamian case, all anchor the propriety of the judge rejecting the submissions by Dr. Moonilal, by Mr. Ram Logan, and Mr. Ramdeen. I can tell you that yesterday I attended court myself on this matter. I witnessed the submissions coming from counsel. I noticed that Mr. Ram Logan was in a very tight position and even took to certain outbursts at the bar, which were uncharacteristic of the type of submissions that one would expect. But this is certainly a victory for the Constitution of the Republic of Trinidad and Tobago. It is a victory for the separation of powers. It is a victory for the autonomy of the Parliament of Trinidad and Tobago. And it avoids a breach of the separation of powers, which can be very expensive for the citizens of Trinidad and Tobago. If we were to allow the immunity and privileges of the Constitution in Section 55 to be eroded by access to the court on a whimsical basis, we would be making a mockery of democracy. Importantly, what is following from this decision, even though we've not received the reasons of the Honorable Judge just yet, what flows from the rejection of this injunction is an acceptance that injunctive relief on the allegation of a breach of fundamental rights, that's Section 4 and 5 rights of the Constitution, do not trump the Constitution as a whole. The essential position is that the Constitution must be read as a whole. Section 55 of the Constitution, immunities and privileges, being anchored in the manner in which Trinidad does it, being anchored in a upholding of parliamentary privileges and practices in the United Kingdom, as our law and Canada, our Constitution and Canada do. That's a very unique position, and we're very pleased that this was upheld by the court today in the rejection of the position. That is my estimation of what the reasons will include, because if the judge felt otherwise, surely the injunction would have been granted today. Victory for democracy, victory for the rule of law, victory for the Constitution, victory for the autonomy of the Parliament, and certainly it allows for the matter of privileges to continue. You must remember that the Parliament is not a court of law. The Parliament is comprised of members of Parliament. The Parliament's privileges and immunities extend to its committees, which are populated by members. It is essentially an important decision because it says Parliament can regulate its own practice. Parliament can regulate its own members. If Parliament cannot hold discipline in the Parliament amongst members in particular, then we are going to invite chaos into our equation. For the UNC to try to have chaos prevail in the Parliament of Trinidad and Tobago by utilizing the court process is certainly an indictment as to the manner in which they propose the law ought to be applied. May I take your questions at this point?
Did the judge give a ruling, or would that follow?
The judge communicated simply whether the injunction was granted or refused, and as the judge indicated in court yesterday, written reasons would be provided if requested.
Did the parties have to bear their own costs?
The judge reserved the matter of costs for the hearing of the substantive matter, which is set for July 8th, 2019. I just remind that this last-ditch effort by the UNC to try and stop the Committee of Privileges report being debated, because mind you, the Committee of Privileges does not make a determination. It submits a report. It is for the House of members sitting in the House of Representatives to debate that report and decide whether there was a breach of privileges. This matter is now certainly one which arose in October 2018. It is a matter which then went to court. It's been 4 months since the matter in court was introduced, and 1 month since Dr. Moonilal was told that the Committee of Privileges would be proceeding because they had removed the undertaking not to advance the case, clearly when the case was not advancing. And for 1 full month, they knew this position, but they went to court in a last-ditch effort to ask for what I would consider to be an abuse of the Constitution to be applied.
Will it be debated today?
Yes. That's it.
Would this somehow improve the quality of debate going forward in Parliament, the decorum that should exist?
That's an excellent question. It certainly will. you must remember you have an immunity and privilege under Section 55. You have a freedom of speech with immunity and privilege under Section 55, subject to obeying the standing orders as to discipline and decorum. And this decision certainly upholds that. So it means that the decisions of the House in keeping its decorum and disciplining its own members has been supremely preserved, and that is certainly a victory for the parliamentary process.
Speaker of the House now today, if we go forward, will there be more power to her to contain certain members of the House?
Well, certainly it preserves what is viewed to be the classic preservation of the power of the Speaker, which is anchored in the Constitution, in the standing orders, and in the House of Representatives legislation in Chapter 202 of the laws of Trinidad and Tobago, and this certainly does anchor that very well.
Is the government prepared from the other side? What may take place in the Parliament today?
Certainly, and I can't be anticipatory of that. You must remember that the UNC also made history when they ejected Dr. Rowley from the Parliament as leader of the opposition. I'm sure you haven't forgotten that. That was the first time in the history of the Commonwealth that that had actually happened. And Speaker Wade Mark made history on that occasion by exercising something which was entirely wrong. At least from the opposition's advocacy, the PNM opposition. It also resulted in Dr. Rowley being paid for his salary, which was withheld, etc. And that is now a matter of public record. So, true to form, I think it's safe to say that the UNC continues to act in the mold and fashion that it does. But I'm very grateful today that the courts have basically upheld the rule of law and the Constitution of Trinidad and Tobago. Yes?
I just have a quick question on topic. I know you mentioned before the marijuana decriminalization, you said the issue is still the end of June or July. Is it still on course?
Sure. Very, very good question. Thank you for allowing me that opportunity. I can tell you that I have completed the drafting process, both with respect for proposals for decriminalization and, very importantly, with respect to the regulations that govern medicinal manufacturing, production aspects of it. Those I must now take to the Cabinet for its consideration. I cannot be presumptive as to what the Cabinet will say, but I'm very pleased to say that after significant public consultation and a significant amount of work, that we have completed that and that we appear to be on track for our commitments on this particular matter.
Should this be debated in Parliament as an issue? Should it be debated in Parliament?
Every law is debated in Parliament if one proposes an amendment to the law. In this case here, the Dangerous Drugs Act is what regulates the production, possession, etc. of cannabis, and clearly an amendment to the Dangerous Drugs Act is what we're talking about. There are some food and drugs aspects tied in as well with the regulations under the under the Dangerous Drugs Act. So they're effectively two large pieces of law to be decided on two separate issues. One, the possession side and decriminalization side, and the other on where do you get it from and what can you do with the thing. If you're going to have the licensing of medicinal marijuana, the production, the distribution as the rest of the world is looking at, that's a separate issue which falls under the regulations of the Dangerous Drugs Act and also the regulations and substantive law under the food and drugs regime.
Could you tell me, are there any circumstances where the court could preside over the matters of Parliament?
Of course, it would be possible that a court can, whilst not offending the separation of powers principle, involve certain considerations of Parliament. However, the question is if it's going to run to the route of tripping the privileges of the Parliament or the separation of powers principle. In the separation of powers principle, the court is there to interpret the Parliament. The court is there to interpret the Constitution. And under its interpretive function, it can certainly have an intervention on certain matters.
How dangerous it is had the court ruled in favor of Mr.
Dr. Moonilal? It would have been a landmark decision if that had been given, which would have been in contravention of our Constitution, and it would have stood in opposition to case law coming from the Canadian jurisdiction in particular, which is quite similar to ours, where you would have had a serious inconsistency between the application of laws. Remember, our Constitution is unique in Section 55(3) in particular, which is the privileges and immunities section. And had the judge gone the other way, certainly there would have been an appeal on the matter, and the government would have been prepared to go all the way to the Privy Council to settle that law.
The timeline now, is there any chance that the Dr. Moonilal might appeal it, or is it so? Because I'm looking at the looking to watch. Is it too short?
We're on deck now. So we're in the Parliament now. I'm confident that an appeal cannot happen between now and the management of the Parliament's exercise. It isn't to say that there couldn't be an appeal on the esoteric principle as to whether there was a breach and whether damages should flow. Obviously, those things are still preserved. The question is whether one can interrupt the process of the Parliament at present. I must beg an apology to run off on you now as we're starting at 1:30, and I also have to today debate the local government reform, which is on deck. Okay, thank you so much, members of the media and listening public, for tuning in and tuning up.